Okay, we're back in regular session, the Central Arizona Fire and Medical Authority. And at this time, we're going to take old business. Item A, motion, discussion, and action regarding chief's contract term regarding indemnification. Clarify direction given to staff for the May 24th, 2018 board meeting. Item 8C, including a dollar amount of $1,650. Do I have a motion?
Second.
So in this time for discussion, I would like to clarify that this has already been approved, and what we neglected to do was include the dollar amount in the public record of $1,650. And so we are correcting that now. Do you have anything to add, Chief, or did I cover that? Chief, okay, I just want to make sure. Any other discussion? Okay, and I will call for the vote to approve it as read into the record. All in favor?
Aye.
Aye, and that was unanimous. Thank you very much. New business, discussion regarding the proposed amendment to agreement between Kenderhammer Partners LLP and CYFD to reimburse legal fees and costs related to responses to administrative and legal action against Nicholas Cornelius arising from actions of board members. And at this time, I just want to start by saying that the way this was worked was actually premature. From the standpoint that we're not proposing, have not had a proposal for an amendment. What we're realizing is that there was no indemnification clause in the contract, which is a normal course of business, and that will be taken under advisement for a future date. However, wanted to make clear that conflicts of interest have been discussed numerous times at length. When we first started with CYFD and CVFD, this was something that was very pertinent. In fact, prior to CAFMA joining, was when CYFD had Mr. Cornelius and CVFD considered taking him on. So this was before the JPA. At that time, we did take him on and felt that based on the conditions, that if the conflict arose, that we would, I'm just gonna say it, Chino, that Chino would be required to get the outside counsel, and that Mr. Cornelius would stay with Central. And from the CAFMA perspective, that followed suit. So if there turned out to be a conflict, either between two or all three of the parties, that Central Yavapai would retain the services of Mr. Cornelius, and the other two agencies would be required to seek outside counsel at that time. From an administrative perspective, we felt that it was suitable to go forward, and we have done so. In fact, several months ago, it was requested to be on the CYFD, the Central Yavapai agenda, that he be considered to be fired, and that board, by majority, declined. So they have retained his services, and by a majority of the vote. I realize that there's still a philosophical disagreement on that, but at this time, there's no substantive examples of conflicts, only theoretical. Should substantial or significant or proof of any conflict of interest present themselves, then as reasonable people, we would absolutely consider a situation that would be considered a conflict of interest, and we would take it up for consideration. However, at this time, we have discussed it and heard from the public multiple times, and we feel that, at least for this board, speaking specifically for this board, that there's nothing further that we have to hold on to, that there is an actual conflict of interest, only theoretical, and we're not going to take action on that either. And there's no direction or there's nothing for us to vote on. So we're going to move on from that. And at this time, like I said, the amendment to any contracts for indemnification is premature, but we did realize that we do need to consider an indemnification clause, as is customary in contract law, as well as look at a procedure that would follow. How do we actually enact such an indemnification? And that is lacking, and we will take that issue up. And that is the direction that we're giving to staff to take that on. At this time, I would like, though, for the record, for Attorney Cornelius to clarify what preempted this for even consideration for the public's benefit, so that we can have that in the public record.
Sure. Sorry,
thank you, Madam Chair. And I want to thank the members of the audience that thought enough to come up and give me their insights regarding this matter. I have not been sued, as someone mentioned. What has happened is that I received a copy of a letter generated by two board members, Director Jacobs and Director Steele, suggesting that there were multiple conflicts of interest and other outright mischaracterizations, fraudulent, or strike that, false statements, which was purportedly sent to the Arizona State Bar. I have not heard from the Arizona State Bar. I have not been sued by anybody. I have not received correspondence from any other third parties or agencies. But I do not have an indemnification provision in my contract. I've never had this happen. I've been practicing since 1991. Nobody's ever taken a run at me like that. Having said that, with regard to the question from Mr. Cugno, is it appropriate to have indemnification provisions in other independent contractor agreements? And the answer is yes. Every single IGA that has ever been offered to any of these agencies before the creation of CAFMA has indemnification provisions. Private contracts offered to these agencies have indemnification provisions. That is, if there is some kind of lawsuit or action that is taken, there is a basis for seeking reimbursement for those fees and costs. I don't have anything like that in my retainer agreement. Never have, never come up before. In this instance, if you're dealing with a situation where there's an elected board and the majority of the board feels you're doing something wrong, you get your walking papers. I serve at the pleasure of the fire board. If a majority tells me they're done, then I'm done, and that's the end of it. I've never had a situation where a minority has tried to suggest that acts taken have resulted in conflicts of interest. But I'm not entirely clear of whether Director Jacobs and Director Steele understand the import of the suggestion. That means that all of those acts that were taken may in fact be inappropriate, notwithstanding the fact that they were voted on in executive session or discussed in executive session, voted on in open meeting. There is a basis for talking about ratification of those kind of things, and a whole series of additional issues that arise from the suggestions that were made. But what I have determined was necessary to do after consulting with outside counsel was advise the board of these issues and advise the public of these issues. So that's what I've done. To the extent that there is going to be a procedure in place to address the concerns that Mr. Albert raised, I would never suggest to the board that they should indemnify me and that I would advise them to do that, sir. The whole point is to advise them as to what their rights and responsibilities are and that they must retain outside third-party counsel to advise them in that regard. And that was the basis for discussing that in executive session. Can't discuss that in open meeting until the board is aware of their responsibilities. So that's all I have to say on that issue. Thank you.
Thank you. And just one clarifying point for the public's benefit, and that is that when any of us are acting in the scope of our authority as elected officials or as contractors, then that is the purpose of indemnification. It is not to cover anything that's egregious outside of the scope. And so we would absolutely take that up, would it be discovered that anything like that existed. And so, like I said, at this time, we feel that any language is premature. We're going to have the staff put something together. And so I just wanted to reassure, because multiple people were concerned about this issue, and that it is serious to us. And if there is any other board member who would care to not to participate, so I'm not the only monologue, please feel free to comment at your own will. Thank you. Left me hanging out there. No, I appreciate it. And I think it's very important that we're serious about what we're doing, and we don't take these things lightly. And that when the majority of all these boards are learned and engaged in our community and business people, so we're not looking at it just from we're not funneled in this. We're actually looking at this from our whole scope of experience and participation and active engagement in what's going on. So I think we're done with that. Thank you very much.